Hello and welcome. This lecture is about judicial precedent and should help those of you on an LLB degree course or an associated degree. The subject of judicial precedent is a notoriously difficult concept to explain, yet both lawyers and law students alike will spend much of their time thinking about and engaging with this. At its most basic, it is about reading cases and understanding judicial reasoning. It is something that is practiced throughout a law student's time in study or a lawyer's time practicing. In short, judicial precedent is fundamental to the common law. It is the way in which the common law develops. A working definition of judicial precedent is that like cases are decided in the same way. That is, cases that are considered to be alike. This raises a question as to what does like cases actually mean. What is meant by those cases that are considered alike? This is referring to alike in law and fact. The distinction between law and fact is a technical and important one. This can be illustrated by Lloyds Bank plc and Rossett. The facts in Rossett concerned a couple who had renovated a derelict farmhouse. One of the couple was the title owner of the farmhouse. The dispute was whether or not the non-owning spouse could claim a share in the property. In analysing this case, we need to look at equitable principles, the way in which equity can be used. The use of an equitable device, such as a constructive trust, to lead to someone being able to obtain a share of the property as the non-property owning spouse. The facts in Rossett are the ownership, and the legal issue is how the device, the constructive trust, can be used to allow the non-property owning spouse a share in the property. Due to precedent, it follows from this that if another case arises that is considered by the presiding judge to be sufficiently similar in law and fact, then it would be bound by the case of Rossett, bound by the decision in Rossett, by the same rule of law as laid down by the judges in Rossett. So, continuing with this line of thinking, there are some matters of definition that we need to deal with. It is possible to come up with a definition of precedent, something like this. If the instant case, the case we are dealing with, the case the judge is trying to decide, is considered sufficiently alike in law and fact to an earlier ruling in a precedent case, then the instant case is bound by the rule in the precedent case. So the two key features of the doctrine of precedent are that firstly, the proceedings are binding. What do we mean by this? What do we mean by binding? In order to answer this, we can cast our mind to the distinctions between civil and common law. What characterizes civil law is a binding code precedency. Cases tend to be illustrative and not binding as the code is binding. In common law, however, the precedents themselves are binding as there is no code. So what we are looking at when we look at the doctrine of precedent is a doctrine of binding precedent. This leads us into the second feature of the doctrine of precedent, and that is the hierarchy of the courts. For obvious reasons, this is a fundamental feature of the doctrine of precedent. The general rule is as follows. Courts superior in the hierarchy bind the courts inferior to them in the hierarchy. In reality, it is more nuanced than this, as courts have appellate and trial jurisdictions. Therefore, and it should be apparent that precedents are determined by the more superior courts, the Court of Appeal Civil or Criminal Division, and the House of Lords, now the Supreme Court. We are dealing now in this lecture primarily with the domestic courts, so we will put aside the ECJ and the European Court of Human Rights. A major scholar in this area, Cross, quotes, "What characterizes the common law system of precedent is the respect paid to a single decision of a superior court, and the fact that a single decision is always binding precedent with regards to the courts below the court which issued it." This quote encapsulates the two key features that precedents are binding and that the hierarchy of the courts are of fundamental importance to it. We need to elaborate on some of the definitions in this area. Whilst referring to precedent, we are referring also to ruling, or to give it the proper name, the ratio decidendi. The ruling or principle, the rule of law for which a precedent case stands as authority. There is a way to distinguish between the ratio of a case and everything else, the distinction between the ratio and the obiter dictum. The obiter is everything else said in the case. The practice of law is all about reading and managing to tease apart the ratio and the obiter. This is the work of lawyers. So you may be asking, why are we concerned with the technical details of the hierarchy of the courts? The answer is that they are essential to judicial lawmaking. They make lawmaking as far as possible coherent and consistent, and provide a structure of argument that is fundamental to the law. Legal decisions are not arbitrary. Judges must give reasons for their decisions. To a certain extent, those decisions must be seen as coherent with the decisions made in the past. I have purposely broken down the doctrine of precedent into 3 separate lectures, as the topic's often quite hard to grasp, but it's a fundamental for those studying LLB or law in general. So if you enjoyed this lecture, please go on to my second lecture in the series regarding judicial precedent. And if you'd like to subscribe to my channel, that would be great and very supportive. I also have my email address in the link if you'd like to contact me with any questions, and I have my website domain name there also, uklawlectures.com. Thank you for watching.